Hi, this is Sheri Jolly with Dental Support Essentials, and today I am talking with Justin Withrow, who is an attorney at Flannery Georgalis in Cleveland, Ohio. And we're going to talk today about things that dentists should know about before they actually need them. So Justin has spent a lot of time in the last few years working with dentists on in a legal capacity. And one of the big things that we talk about quite a bit is things that if they had just known, if they had just been better at, or things that they could have done to protect themselves a little bit. And so we kind of wanted to bring that up and kind of spread the word a little bit. So the big one, and I preach this all the time, is documentation, documentation, documentation. I have seen this when as an office manager and as a biller, I have seen where I can't get something paid because I don't have enough documentation to prove it was done. But on your end, Justin, what have you been seeing when documentation is lacking?
Well, first of all, Sheri, thank you very much for inviting me to participate in this today. I'm really excited for the opportunity. I think this is really great, and hopefully through our discussion, we'll be able to provide some really valuable insight to, all the providers out there. To answer your question, improper or insufficient documentation can really have a multitude of effects on a practitioner. So, in my experience, I have seen it on a variety of levels, whether it be documentation issues relating to an audit done by either a private insurance company or a government payor. It could have an impact on an investigation that's being conducted by the respective state dental board. And certainly it can also come into play in perhaps a biggest concern is when a practitioner may be under investigation by some sort of regulatory body and law enforcement entity, whether it be on a state level or certainly at the federal level.
Yeah, so that's, I have helped Justin with a project or two when involving documentation, and that is very true. One of the things that I learned a couple of years ago that I thought was interesting is that when you're audited by an insurance company, it's not always just those members of that plan whose charts get audited. If you have signed a network agreement, the insurance company can in fact audit all of your charts, not just the members of that plan. And a lot of doctors don't know that. They think it's just those, the people who have that particular plan. But what kind of effect can it be where they're looking at not just one group of, maybe 60, 70 patients in your practice, but your entire practice?
Let me first address something regarding audits just generally. I think there may be a misconception out there that when a practitioner receives a notification from a private insurer or Medicare or Medicaid requesting certain patient records that are under audit, that the issue is isolated only to an audit. That it's simply not true. And in fact, I've seen this in my own practice where audits done by insurance companies are the precursor to larger either state dental board and more commonly federal law enforcement investigations. And so when you have a situation where the auditor is requesting a wide scope of patient records, they're really trying to identify if that practitioner is billing, is an outlier for billing purposes for certain procedures, whether it be restorations, whether it be root canals. They've come to a point based upon their review of information that this provider may be an outlier, and additional investigation needs to be conducted, not only from an insurance payment perspective, but also from, is there some bad actor here? Is there criminal conduct that's going on that we need to step in and facilitate the investigation by federal authorities to not only stop the improper billing, but then ultimately lead to sanctions for the practitioner.
So when they get that notification of a request for records, should they just immediately open up their charts and mail the stuff off? What should they do when they get that first request?
It's a great question. In my practice, I view a audit request in the same way that I view a subpoena. And oftentimes dental providers and other medical professionals, unfortunately, may experience a circumstance in which they receive both. But ultimately, what you need to do at that point is you need to hit the pause button. And what I mean by that is you need to conduct an internal investigation to identify what is it about the records that they're requesting. Are there deficiencies in our practice? Have we done things improperly? In most cases, unintentionally, and in certain unfortunate circumstances, there are intentional bad actors. But they're asking for specific patient charts and specific patient records for a reason. And so in receiving an audit letter, much like you would if you were to receive a subpoena, you should be contacting competent legal counsel to advise you and counsel you in responding appropriately. Because there are circumstances in which requests for records are overly broad, whether it be the amount of records that are being requested are just too many, or the information that's being requested from the patient records is too wide in time. So oftentimes, if competent legal counsel is engaged early on, they can facilitate a process in which the scope of the investigation or the scope of information that ultimately has to be produced can be narrowed, or can be facilitated in a way where it can be produced over time, or additional time can be provided so that there isn't this mad dash to compile all the requested documentation while also still trying to run a practice.
Well, and those types of, you know, in the few projects that I've worked with you on, it is actually something that does actually stop the motions of your daily practice, because it is usually a huge scope of things. I do know that occasionally I have run across practices who don't know legal terminology and things like that. And one of the things that I'm glad you mentioned was a subpoena. So I have seen sometimes where the staff doesn't know what subpoena means. They know it's a legal term, and it's almost cause for them to hit the panic button and maybe knee-jerk react into something they probably shouldn't do. So when you get a subpoena, like the word subpoena, or you hear the word subpoena from an inspector or something like that, what should be the appropriate response to the word subpoena?
It's a great question. So anytime a provider receives a subpoena, and it may sound simple, but the first thing that should be done is read it. Make sure you understand what is being demanded of you, because that's ultimately what a subpoena is. A subpoena is a demand. Now, in certain instances, it can be a demand for documentation, and that's typically what subpoenas, the form subpoenas take, is they're demanding the production of documents. There are certain circumstances in which a subpoena can request that an individual that is producing the documents also be made available to answer questions regarding the documentation. But generally speaking, a subpoena is a demand for documents. And the subpoena should, if done properly, should identify with specificity the documentation that they're requesting. So once a practitioner has unfortunately received the subpoena, has read the subpoena, then the next step should be to contact legal counsel. And for some of the reasons that I stated previously when I was discussing audits and how audit letters really take the same form as a subpoena, when counsel is involved at an early stage, they can facilitate a more cooperative process. One, we need to identify why is it that a subpoena was received? What is it that whatever the actor is, whoever the actor is, whether it be a state dental board, whether it be local or federal law enforcement, why is it that they're requesting your records? Okay, what is it that's going on here? So one, it's important to conduct an internal investigation to identify what, if any, problems we may have internally that need to be addressed. And then two, as I mentioned previously, counsel can, and it's really improper for the dentist to be communicating directly with the regulatory body. That should be done through counsel. Counsel is more well-versed to facilitate a productive, cooperative conversation, to increase the amount of time that can be provided in order to respond, to hopefully narrow the scope of whatever the investigation is. And also what's important to realize is when someone receives a subpoena, they cannot be ignored, okay?
Right.
It is an obligation and a demand to produce those records. And in certain circumstances, if a practitioner receives a subpoena, ignores it, that is grounds for discipline action against that provider's license by itself. I know that that's certainly the case here in Ohio, where I primarily practice, and I know that other states have grounds for discipline where a provider has failed to cooperate in an investigation process.
And that's the other thing that I really would like to just point out is that a subpoena does not mean right now. Many times there's a time frame in which they say you need to reply within this amount of time. So I'm thinking of a circumstance that I heard of, I was involved in, where the staff thought the subpoena meant immediately. And they should have waited, they should have gotten counsel, and they would have gotten a different, less painful outcome. So just because I'm a dental nerd, I have to make a dental joke about this. And that is, when a person has a problem and it's small and they go to the dentist when the problem is small at the beginning, it hurts less and it costs less. And with legal issues, things like requests for audit and things like that, it's the same concept as a dental issue. When it's small and you get it early, it hurts less and it costs less.
That's exactly right. That's exactly right. And let me just address, the point you made about when a subpoena is received, how much time do we have to respond? Generally speaking, in addition to the subpoena specifically identifying the records that they are demanding, it should provide a time period in which those documents need to be produced. It should identify who to produce them to and when they need to be produced by. Now, again, with counsel involved, those deadlines are often flexible and can be extended, or documentation can be provided on a rolling basis, meaning if they are requesting patient records for 20 patients, you can provide them in batches of 5 or in batches of 10, because investigators understand that it will take some time to compile the information that they've requested. Now, again, here in Ohio, the dental board is required by statute to allow a provider at least 7 calendar days to provide the documentation responsive to a subpoena. There are circumstances in which a subpoena means provide the records immediately, but that needs to be clearly identified on the subpoena. And that's for the extraordinary circumstance. And typically when a determination has been made that that provider is a danger to the public. And that's not something that is common. And it's much more common that a board investigator or a law enforcement agent will provide additional time if necessary to compile the requested documentation responsive to the subpoena.
Okay. Well, so I want to circle back to documentation for just a minute. One of the interesting things I learned when I was helping with one of the cases is that there are certain investigating agencies that do not hire dental professionals to audit dental records. And that blew me away that they didn't have, I mean, I always just thought because there's a dentist identifying dental records in law enforcement that they just had a dentist on staff to look at dental records, and they don't. And it stood out to me that the point was made. It was a training published by Department of CMS, the Department of Medicaid or Medicare and Medicaid. And they said, make your records clear enough that a layman can understand it. And I thought that was very interesting because I have been to enough offices just as training and setting up systems and things like that, that sometimes you can't understand the doctor's notes because it's shorthand, it's abbreviated, it's not universal abbreviations. So what have you seen as far as like at uniform documentation? I'm thinking like in dental school, they teach them SOAP notes and there's a standard format. Is that what you recommend as far as documenting their charts and things like that?
Yeah, I think as you put it, I'm not a dentist myself. And so if I am brought in to assist a dentist in some sort of investigation or audit, undoubtedly, I'm going to be in a position where I'm reviewing patient records. And we're going to be discussing various procedures and various treatment notes and encounter notes of that patient to get a better understanding as to, okay, what is it about this patient that the state actor, the federal actor, or the insurance company is interested in knowing more about. And so if practitioners can make it a focus of their notes to write it in layman's terms, understanding that seeing X number of patients a day, having to document X number of procedures for patients is an arduous and time-consuming process. Almost every time when put into a situation where their notes are undergoing scrutiny, it has always benefited that practitioner who spent the extra time to thoroughly document medical necessity, thoroughly document consent, thoroughly document any issues that transpired during the procedure or in the recovery after the procedure, any follow-ups that were made with the patient. If all of that is documented and understandable to the layman, then undoubtedly that is going to put that practitioner in a better position if their charts are undergoing scrutiny. Because as you said, oftentimes the investigators that are reviewing these records are not dentists, have no dental training. Now they receive significant, sophisticated training, but they're not dentists. And so your charts will be scrutinized by a non-dentist. And so to the extent you can make your entries understandable to those individuals that don't have dental training, it will undoubtedly put you in a better position. It doesn't mean it's going to make whatever the issue is go away, but it will make it much clearer to whoever is reviewing those charts as to what happened on that day with that patient.
I'd like to emphasize, particularly when things are not evident on x-rays, it would be very beneficial to document why you came to that conclusion, because the go-to is always x-rays, it's bite wings. But there are times when you're not going to see what you saw with your eyes on a bite wing until it's much bigger problem. And that's just a dental thing. But an intraoral camera will be a great friend, and so will actually just a camera itself. Taking photographs is actually very, very beneficial. It's beneficial on my end, getting claims paid. I have noticed that with one particular state insurance, that the reviewers of prior authorizations are identified as nurses, not dentists and not dental professionals. And sometimes when we send a picture with the authorization, it goes through. because it makes it clearer for them. So I just, intraoral cameras are not as expensive as they used to be. They're plug and play now. You don't have to buy extra stuff. So it's definitely worth a doctor's investment to document with photographs as well as x-rays the patient's oral health.
And if I could just make a point to that, Sheri, that comment reminded me of a case that you and I worked on together, where it was a West Virginia dentist who had a heavy Medicaid practice in an area of West Virginia. It was impoverished, and the individuals that he treated was largely a pediatric practice, and poor oral hygiene ran rampant through that area and with his patient base. And so it wouldn't be uncommon for children to come into his practice for a cleaning once every 2 years, or once for the first time in their life and they're 13, and have poor hygiene habits, have poor diets. And when the practitioner was in their mouth, it was pretty clear that there were multiple surfaces on multiple teeth that needed restorations. But where the practitioner fell short in his practice was on a few different fronts. It was record keeping was deficient. And not only was it deficient, but oftentimes it was extremely late in being charted. So he had a process where he would take handwritten notes, and then it would take him, days and in some instances weeks to get the final encounter note into the patient chart. And to your point regarding the x-rays, there became a point in time where this practitioner was under investigation by the federal government and the FBI and OIG HHS, the Office of Inspector General for Health and Human Services. And they were questioning whether he had performed all of the restorations and other services on a significant number of patients. And the reason why they were questioning that is because he was a high producer. He serviced a large Medicaid area. He was a high biller when compared to other Medicaid billers throughout the state.
Outlier.
Exactly. He was an outlier. And then when the government began to investigate him as a result of an audit, the government began to investigate him criminally by going to subsequent providers of his patients, whether it be other dentists that treated the patient, certain orthodontists that treated the patient, and they began compiling x-rays. And they started taking these x-rays and examining them to see if they could identify certain restorations that our client had billed as certain surfaces of teeth that our client had billed as performing restorations on. And as I'm sure most of the individuals that are going to watch this video know, that taking an x-ray and trying to identify which surfaces of a tooth have had a restoration done or not, or whether the restoration goes all the way down into the dentin of a particular surface, is next to impossible.
Well, and also the age of the x-rays and the pool of information these other dentists had to look at, it was flawed. But I love the fact that it was the ortho records that saved the day. So patients, there was a photograph of the, so if you're a dentist, in ortho, they take the arch, the lower arch and the upper arch with the mirror. And those photographs were photographic evidence of restorations that existed that were not evident in the other ways of investigation, particularly without actually physically calling the patient and performing an exam, because they did not do that. They did this without examining patients. That's another point. So photos to save the day.
That's right. And so just a few more points on what they did is they didn't try to examine the patients, and instead they went totally upon these x-rays. And so our client was under federal criminal investigation. A search warrant was executed at his office. It was a regular business day. he's not yet to the office, and he receives a phone call from his staff around 7:30 a.m. that the FBI is at the office. There's approximately 25 armed agents, and they have a search warrant, and they're taking all of our patient records. And so, that event transpired, and it was traumatic not only for the staff and for the provider, but for the community, because then misinformation filtered throughout the community, thinking that our client had done these improper things, thinking that the office was temporarily or permanently closed. And so that had a significant impact on his ability to, provide for his family. And then as Sheri indicated, we conducted an investigation, and it was challenging because we were trying to prove restorations that were performed in certain instances 5 to 6 years later, that on individuals that had poor hygiene and had, in all likelihood, had fillings performed on those teeth once or even sometimes twice since the original restoration that was under investigation.
Non-compliant population.
Exactly. And so thankfully, as we started to investigate and contact local orthodontists for those patients that we determined had gone to an orthodontist, those photos that Sheri mentioned were really what saved the day. They clearly identified the surfaces of the teeth that had restorations on them, or where you could see where the prep work had been done for a restoration, and because of poor hygiene or other factors, that the restoration had since fallen out. And ultimately, that assisted us in having the federal criminal investigation shut down, and our client faced no federal criminal charges. His license wasn't sanctioned, and he's practicing and happy today.
Yes, and that is the one thing that really weighed heavily with me, is when everything was cleared, he still paid quite a bit of a price because he was in a small community. It affected his livelihood. And so it's really important that compliance measures and documentation measures be implemented in your practice, because even in this situation where there was a happy ending, he ended up cleared. Well, not cleared, but everything stopped and he was able to go on and practice and continue his livelihood. He had to implement compliance, certain types of compliance measures in his practice that he had never done before. And once again, going back to that, when it's small and at the beginning it costs less and hurts less, this is the same thing. Having a good, strong compliance program, and this, I'm not talking about some overwhelming thing that you have to overhaul your practice, but you need to implement some key policies and some key procedures that are checks and balances for your practice that will, in fact, if you're ever questioned, if you're ever asked, will kind of make this easier for you. So Justin, you talk about that compliance is so important. And you said there's 7 criteria that what are the 7 criteria?
Sure. And so let me just, before I get into the 7 fundamental elements here, everything we discussed, whether it be proper documentation of medical necessity, proper record keeping, a protocol in place as to how we should respond as an office if we were to receive an audit letter or a subpoena. Those are all things that should be addressed in some form of a compliance program. Now, the Office of Inspector General understands, and they put out guidance for practitioners to use to try to create and tailor a compliance program that fits their practice. This is not a one-size-fits-all concept. It can't be, because a practitioner that has offices in 5 or 6 different locations, has 6 other dentists on staff, the compliance program that would be appropriate for that practice is different than the compliance program that was appropriate for my client in West Virginia that serviced a heavy Medicaid population in an impoverished area. The compliance programs were nothing alike. But to answer your question directly, and I'm just going to read them off here, is The 7 fundamental elements of an effective compliance program are as follows. 1, implementing written policies, procedures, and standards of conduct. So by having written policies and procedures, this allows dental offices and other healthcare organizations, OIG in the Department of Justice suggests compliance programs for all healthcare organizations. This isn't something that's specific to a dentist, but it allows healthcare organizations to establish bright line rules that enable employees to avoid violations, and then also how to respond if violations or other improper conduct are identified. Number 2 is designating a compliance officer and a compliance committee. So depending on the size of the organization, it may only be appropriate to have a compliance officer. And so a compliance officer would be the one that is in charge of the compliance program, making sure that it's properly enacted, making sure that all employees know what the policies and procedures of the compliance program are. And then ordinarily, they would be the individual that if a subpoena or if an audit request or if a search warrant was being executed at the office, they would be the point person. So they would be responsible for discussing next steps with the dentist if the dentist is not the compliance officer, and in most instances it should not be. And they would be responsible for facilitating a response, and ordinarily that would be through outside legal counsel. The third is conducting effective training and education. So all employees need to be trained on the unique compliance issues of that company. As I said before, this is not a one-size-fits-all concept. Each entity in each office is going to have different needs for education and different needs for training. And it's important that the compliance officer identifies what those needs are and make sure that all staff is receiving the appropriate training, and that is documented so that if there is a circumstance where it is questioned whether staff has received the appropriate and sometimes state mandated training, that is all easily accessible and able to be produced if necessary. The fourth step is developing effective lines of communication. And this perhaps is one of the most important steps. In an organization with a compliance program, the employees are going to, generally speaking, be the ones that can identify the shortcomings or the issues that would trigger a need to take some sort of action. They're going to be the ones that see, improper documentation and patient charts. They're going to be the ones that see, abnormal billing or abnormal billing protocols or deficient consent being received. And so the employees need to be able to effectively communicate with the compliance officer and know that by raising complaints and raising issues that they see within the practice, that they're not going to face some sort of unwarranted sanction, be disciplined, be terminated, be suspended for reporting conduct. And so they need to feel comfortable that by reporting things that they feel are improper, that they're not going to be suffering from retaliation or backlash. Right. Number 5, and this is a long-winded answer, I apologize, but the fifth step is conducting internal monitoring and auditing. So really the only way that you know if your compliance program is working is by periodically putting it to the test. So having certain individuals, generally speaking, you're going to want professionals outside of the office, either yourself or legal counsel, or even a combination of the two is probably what makes the most sense, to come in and conduct periodic audits of the practice. Review billing records, review patient charts to make sure that what is identified in the practice's compliance program is actually being carried out. Because if if you have a compliance program in place, and it could be the best thing in the world and it could address all the various issues, but if it's not being implemented and it's not being tested and it's not being adapted to fit the needs of the practice, then it's not doing its job. And so if you get into an instance in which there is some sort of investigation and you want to rely on the fact, and oftentimes you can receive credit for having a compliance program, you're only going to receive that credit if the compliance program was effective and was working and was doing things that it should have done. And exactly, and being used. And so the sixth step is enforcing standards of conduct and well-publicized disciplinary guidelines. So when improper conduct is identified through the compliance program, there needs to be uniformity and there needs to be well-known disciplinary standards that all employees know, that all employees accept to adhere by, and that all employees understand are going to be implemented if certain things are discovered. And so go ahead.
I was going to say, and to just kind of put this into my everyday business, this applies to not just your billing, not just your record keeping, but your HR and your HIPAA and your OSHA, which you probably, if you're doing anything, you're probably already doing something for HIPAA and something for OSHA because it's required in most places. So, you know, what he's talking about here is like, just like when you put in your manual that this, if you violate this policy, you might get written up. If you violate this policy, those are all encompassed in this. This isn't just your billing. This isn't just how we submit claims or how we collect money. This is how we run our practice: HR, OSHA, HIPAA, billing, all of the above.
That's exactly right. And so an effective compliance program is really going to address all potential aspects of a practice. Like Sheri said, this is not a billing and charting focused endeavor. Rather, this is something that a new employee would receive a copy of a compliance manual, and it's sometimes known as sort of like the practice manual or the employee manual, and they're going to be able to read through it, and they're going to be able to understand what is and is not acceptable at this office. And so it's something that needs to be clear, it's something that needs to be thorough, and it's something that needs to be enforced. Because the seventh step of an effective compliance program is responding promptly to detected offenses and deficiencies within the program. So if issues are brought to the compliance officer's attention and nothing is done about them, or there's insufficient reaction and response to the problems that are brought to the compliance officer's attention, then the compliance program isn't working. And so it's important that the compliance officer understands and appreciates how to effectively respond to the issues that are brought to them. You know, if it's a billing issue that is small in nature and is caught pretty quickly, that is something that would not trigger the same response to, billing for services that weren't rendered over a significant period of time. How one responds to those two different things should be and generally would be different.
Right. Sending a corrected claim is something that will happen in everyday business. There's going to be a time when somebody in the back marks something down, the biller sends it out, and then find out, oh, I didn't do that. Sending a corrected claim is everyday business, but sending 1,000 corrected claims, that's a different story. But you do need to know how to self-correct. It's very, very important. But if anybody is watching, I want them to be encouraged that almost every dentist has a partial compliance program going on in their practice. And, talking to Justin or the people at his firm, they're probably going to take what you already have and just make sure that it helps you and is effective in a time of need. Now, there may not be a time of need, but given that how easy it is to make a mistake and violate HIPAA, given like just with your email. Like there's so many rules about email, and then you hire a new person and they click the wrong button and they do something incorrectly. It just takes the wrong patient to get that email, honestly. And most of the complaints that come against a dental practice are usually reported by either an employee or a patient. And it's most of the time somebody who's unhappy. So when I talk to doctors, I talk to them about their billing practices, and I say, let's go look at the Google reviews. They're almost always about billing, right? Somebody's going to complain when it's involving money, things like that. So these are things to protect yourself. Like if this mistake happens, because we hire humans and humans make mistakes, how can we fix that? And I love that that's kind of the last part, the safety net of it all. When these things do happen, we have a plan to fix them. And I'm sure, Justin, you know about like common blunders that happen in a practice.
Sure, and let me address one thing first. If you're evaluating the effectiveness of your compliance program at a time of need, it's too late. Yeah. You should be evaluating your compliance program. First off, it should be regularly, whether it be annually or biannually. It needs to be regularly reviewed to ensure that it addresses all the areas of a practice. Currently all practices are in the world is dealing with COVID-19. Mm-hmm. You should have some sort of additional policies and procedures as to how you are going to implement appropriate COVID-19 protocols, safety measures. I understand that there's new billing codes that practitioners can use for conducting COVID testing. So that all needs to be addressed. And if it's not COVID-19, it's something else. I see lots of instances of text message communication between staff and how that can lead to problems, and staff having text message communication about patients, and then while meeting outside of the office, continuing that dialogue, and non-staff employees seeing that dialogue, that can raise all sorts of issues. Social
media.
Exactly. And who knows what the next thing will be. So it's not an issue has arisen. Let's now evaluate why our compliance program is ineffective. No, it should be things are going well or things are quiet. Let's make sure that our compliance program addresses all the areas of potential need and all the areas of our practice.
Well, once a quarter, every business owner has to review their finances for taxes, right? So why wouldn't you review your compliance programs the same thing? This is, if you can think of it like changing the batteries in your smoke detector, this is kind of what you would test your smoke detectors in a periodic manner. Your compliance program needs to be thought of like your smoke detector, like the fact that periodically you have to look at your finances and report your taxes and things like this. This should just be regular housekeeping, daily business, or periodic business that happens more than once throughout the year. The first time you do it, it's going to be a big project, but after that, it's going to be, let's get this, let's tweak that. And after that, it should be more about just upgrades and improvements as moving forward.
That's exactly right. And as you said, Sheri, while it may not be called a compliance program, most practices have some sort of operation manual that is exactly that. It's the operation manual, and it provides the framework for the appropriate compliance program. And so initially, it may be a taller task than future periodic reviews will be to make sure that the operations manual or the compliance program or whatever it's titled is appropriate and thorough and addresses all areas. But then after that, those follow-up reviews, generally speaking, will not be that expansive and will not be that intensive.
Yes, and I think that that's the, if anybody's watching this and they're thinking about this, that you should take that away, is that you probably already have something, and you probably just need to make sure that it works very well. Kind of like, this is kind of like needing insurance after you've had an accident. Like, you need the insurance before you've had the accident. You need the compliance program before the incident occurs. And, you know, there's a lot of people who drive for years without an accident, but it doesn't mean you'll drive your whole lifetime without one, or your whole career as a dentist without a compliance issue. So we definitely need to, it's definitely a very important thing. And I know that it's been put to the wayside in a lot of practices right now because they're scrambling. But when you're scrambling because of staffing issues, because of being shut down for a couple of months last year, and for patients being afraid, this is actually the perfect time to ensure to your patients that you are doing everything the way you're supposed to. One of the big issues that's happening right now is, now that the vaccine is available, a lot of offices are getting calls, is your whole staff vaccinated? Well, that's a HIPAA violation, so you don't have to tell them that. But what you can say is, we comply with all regulations. We comply with all the rules, all the regulations. You want that to be true by knowing what the rules and the regulations are, and that you have in fact complied with them.
That's exactly right. I mean, I couldn't have said it better myself. Regular monitoring of, the ever shifting world of rules and regulations. It's important that you stay attuned to what those are, and you make sure that your compliance program or the operations of your practice adjust with the ever shifting rules and regulations.
Yes. So if someone were to have questions about a compliance program, or even if maybe they got that request for the audit or a subpoena or something like that, you guys, anybody can contact Justin. His email's here on the screen, at Flannery George Ellis. And then also his phone number for his firm is 216-302-7573. Justin is in Ohio, so he's on Eastern time. But Justin, you can handle multiple states, right? If the doctor's in Ohio, but not necessarily just Ohio, where else can they be from to call you?
Really from anywhere. So my firm, Flannery George Ellis, we have offices in Cleveland, Pittsburgh, and Charlotte. But both myself, I happen to be licensed in Michigan as well, and other members of our firm who, and just to provide you a little bit more information about my firm is comprised of largely former federal and state prosecutors and federal and state law enforcement agents. And so our practice area is largely committed to handling complex regulatory matters, whether they be criminal in nature, compliance in nature, professional licensing, and other complex litigation related thereto. So we have approximately 30 lawyers in our firm, and we're licensed anywhere from Michigan all the way down to North Carolina and other states. And, oftentimes, when handling a compliance project like this, it doesn't necessarily require licensure in that state. But in the event that there are matters where there will be some sort of court action or significant work done in a particular state, generally speaking, we have lawyers that are qualified within the firm that are licensed in that state to handle the matter.
Okay. And I am Sheri Jolly, and I am with Dental Support Essentials. And if you have any billing or office management type of issues, you can contact me. My email is sheri.jolly@dentalsupportessentials.com. And you can call our office. We are also in Ohio at 740-951-0528. We do a lot of, mostly the billing. We also do a lot of training for office managers and billers, but I myself am also a fraud examiner. So we can help you sometimes when it comes to an audit, an internal audit, or anything like that if you wanted an outside compliance type of thing. So you can either call myself or Justin, depending on what your need are, and hopefully this helps you, gives you a little bit of information, some things to think about, but a compliance program is necessary. It's kind of, it is mandatory when you own a practice nowadays.
Absolutely. You know, certain practitioners who are bill federal healthcare programs, it is required that you have some level of a compliance program in place. And certainly it's the appropriate practice for all practitioners to have a compliance program that addresses the appropriate needs of your practice.
Just having an employee means you need a compliance program, I think.
That's